Hey everyone, welcome to this explainer. Today we are tackling what is arguably one of the most vital survival skills you can possibly develop in the real estate world, having 20/20 legal eyesight. Our core mission here is to ruthlessly separate real enforceable law from that incredibly loud, legal-sounding internet noise that is currently costing people their equity, their property, and their time. We are going to fix that right now.
Okay, let's dive into this. We have all seen claims exactly like these floating around, right? Things like, recording your document makes it law, or just put it in a trust and the property is completely untouchable. These are incredibly common, but they are very dangerous pieces of internet lore. They promise this easy silver bullet remedy, but out in the real world, relying on these unverified myths usually leads to disastrous consequences, like facing heavy court sanctions or even accidentally accelerating your own foreclosure. It's bad news.
So whenever you see claims like those, you have to stop and ask yourself one fundamental question. Where are the actual legal receipts? Seriously, it is time to stop trusting someone just because they speak with a lot of unearned confidence, or because they shared a really catchy screenshot or meme. If you genuinely want to protect your property, you have to start demanding actual, verifiable, legal authority.
To help you get there, here is our roadmap for building your legal eyesight today. We'll cover 1. The danger of legal lore. 2. Law versus legal lore. 3. Types of legal receipts. 4. The legal receipts test. And finally, 5. No receipts, no reliance.
All right, let's jump straight into Section 1. The danger of legal lore. Beware the noise.
So look, out in the property space, people throw around legal words like statute and jurisdiction all day long without actually understanding what the law says. Let's look at some of this dangerous internet lore. You've probably seen claims that your all-caps name is a corporation, or that securitization automatically voids your mortgage. What makes these claims so unbelievably toxic is that they take a real legal concept, like negotiable instruments, and completely abuse it. It sounds super sophisticated, but it creates a massive vulnerability for anyone who tries to use it when facing a real-world foreclosure, probate issue, or tax sale.
Moving right along to Section 2, Law versus Legal Lore. This is the core distinction you have to master.
And this brilliantly illustrates the hard line we need to draw between online myths and courtroom reality. Real enforceable law is rigorous. It has a verifiable source, a specific jurisdiction, strict procedures, and real-world consequences. Lore, on the flip side, is built entirely on hollow confidence. It relies on screenshots, catchy slogans, and fake templates. Real law requires serious, factual analysis. Lore just requires someone on the internet saying, "Trust me, bro, this works." Let's get into Section 3, Types of Legal Receipts. We're going to rapidly define the actual materials you'll encounter.
So what does a real legal receipt actually look like? Well, first up is a statute. This is a law enacted by a legislative body, like Congress or your state legislature. It is a very powerful receipt. However, and this is absolutely crucial, the most common mistake people make is quoting a powerful-sounding statute without proving it actually applies to their specific judicial or non-judicial situation. A statute is a rule with a very specific scope. Honestly, if it doesn't govern your specific situation, it doesn't matter how great it sounds.
Next, we have regulations. These are rules created by administrative agencies, like the CFPB, to implement laws, like mortgage servicing rules. Now hear this loud and clear. Regulations are not magic wands that automatically void mortgages. They have very narrow scopes. They apply to specific actors, and they usually offer very specific remedies, like actual damages or statutory penalties. They are not a universal cancellation of your debt. Now, what's really interesting about this slide is the massive distinction between an actual case holding and a random quote. A holding is what the court actually decided on a legal issue that was necessary to the outcome of the case. But people online, they love to grab one single out-of-context sentence from the background commentary of a judge's opinion, the dicta, and act like they just found the master key. That is literally how fake law arguments are born. A random quote is not a legal receipt, only the holding is. Then we have court rules. You can think of these as the operating system of litigation. They govern all the procedure: pleadings, discovery, deadlines, and I really cannot stress this enough. Court rules are not just optional technicalities. You could have a totally valid, winning, slam-dunk, substantive property defense and completely lose your case simply because you missed a deadline or formatted a motion incorrectly. Procedure matters. Let's look at contract terms. Real estate is fundamentally built on agreements, so I urge you, please actually read your instruments. It is wild how constantly people argue about defaults or trusts or a trustee's authority without ever sitting down and reading the underlying contract or note. Contract terms define your rights and duties, and you have to read them. Next up is the recorded instrument, and we really need to deliver a crucial corrective right here. Recording a document, like a deed or some ridiculous lien against a judge or a bank, just means it entered the public record to give public notice. That's it. It absolutely, 100% does not prove the document is legally valid or authorized. Recording nonsense just means you recorded nonsense into the public record, and filing false liens can actually expose you to massive liability. Then there are notices. Think of these as the legal warning system. Notices of default, tax sales, or eviction. These trigger massive consequences and ticking deadlines. They should never, ever be ignored. But just because you receive a notice doesn't mean it's automatically flawless, right? You still must test it. Was it legally required? Was it sent by an authorized party? Was it delivered correctly? Is it actually valid under the law?
And finally, we reach the absolute weakest category imaginable, the internet claim. This is any statement in a social media post, a guru PDF, or a comment section that lacks verified legal support. These are only leads, folks. They are not law. Relying on an internet claim without doing the verification is literally like jumping out of a plane with a backpack instead of a parachute. It's gonna end badly. To sum this all up, any serious student of the law has to rank their sources. At the very top, we have highest level authority: constitutions, statutes, binding case law, regulations, and court rules. Next level down are case-specific documents, like your deeds, contracts, and notices. Below that is supporting evidence, like your payment history or tax records. And at the very bottom, weak or non-authority, like screenshots, guru PDFs, and memes. You absolutely must learn how to argue from authority rather than emotion.
Section 4. The Legal Receipts Test. Let's look at a practical methodology.
Let's move and see how this builds a framework that will make you disciplined, precise, and incredibly hard to mislead. Whenever someone makes a property law claim, you must pass it through this strict 5-step test: source, jurisdiction, scope, conditions, and remedy.
Let's break those down really quickly. First, source. Where did it come from? Is it an actual statute or just an internet post? Second, jurisdiction. Where does it apply? Are we talking federal court or one specific state? Third, scope. What does it actually govern? Fourth, conditions. What facts must exist for this rule to even trigger? And fifth, remedy. What actually happens if the rule is violated? Remember, the law doesn't reward the loudest person in the room. It rewards the person who can properly connect facts to authority through proper procedure.
Which brings us to Section 5, no receipts, no reliance. This is the foundational rule.
So the crucial point is this simple mantra right here: no receipts, no reliance. If you are trying to survive real estate and foreclosure disputes, I want this permanently cemented in your mind.
Why is this so important? Because unverified claims literally cost people their homes, their land, their equity, their inheritance, and their credibility. Real law has receipts. Lore is just noise. If a claim cannot be traced directly back to real, verifiable legal authority, absolutely do not build your strategy on it. True legal eyesight requires demanding that verification every single time.
I want to leave you with this final question to think about. What is one legal claim you have seen online that needs receipts before it should be trusted? Think about it and apply the legal receipts test to it today. Start demanding authority, stop relying on noise, and you're going to navigate property issues with the clarity of a true expert. Thank you so much for joining me in this explainer. Keep demanding those receipts, and I'll see you next time.